Have you ever wondered what happens when I die? How should I prepare for this? How should I prepare for the inevitable? Well, today you will want to listen to this show. I have a great expert here to talk about it, and we're going to talk about what no one wants to talk about, what happens when you die, and how to plan for the inevitable. This is Jessica Duncan's Just My Opinion, and I'm Jessica Duncan. There's no handbook to owning a home, and that's why I go beyond the transaction to bring you my opinion on how to make adulting made simple. So I'm so excited today. I have my friend, my attorney, my advisor, Amanda Elliott from My Pink Lawyer here with us today, and we are going to talk about some exciting stuff when you die. I know. Very exciting, right?
So exciting. Thanks for having me, Jessica.
Yeah. So, Amanda, you are a local attorney here in Pensacola with My Pink Lawyer, which love the name.
Thank you.
Do y'all just help women, though?
No, we actually help more men than you would think. So if you will work with a law firm called My Pink Lawyer, we will work with you.
Awesome. I love it. And I love the marketing behind
Thank
it.
you.
But you're the managing attorney there at My Pink Lawyer. I'm assuming it's mypinklawyer.com.
mypinklawyer.com.
Awesome. So we got to know each other a lot better when you actually did our estate planning, which thank you very much for doing that.
You're so welcome. We enjoyed doing it.
So I wanted to have you here on the show to give people guidance. You know, this is something that I think everyone needs to talk about. I have talked about death so much in my life that people, I think I'm a little obsessed with it. And it's not that I want to die anytime soon, but I deal with the consequences all the time of people dying without a plan. And so I think it's really important to talk about. We talk about everything else in life. Why not talk about what happens when we die?
You are speaking my language. And so I am also accused of talking about it a bit more than I probably should. But if you don't talk about it, it doesn't mean it's not going to happen. On the opposite side of that, if you talk about it and you communicate your wishes well in advance, you're setting up your loved ones for future success.
I mean, it is inevitable, right?
It is truly
We are
inevitable.
going to die. There's no getting out of it.
No getting out of it.
Hadn't figured out a way yet. So let's talk a little bit about, let's just start with basic topics, okay? I am single or married or whatever my situation is. Do I need a will or a trust?
That is a great question. So we get that a lot, whether it's I'm, kind of in my building years, maybe I don't have a ton of assets, I'm not married, I don't have kids, do I need a plan? The answer is you actually already have one, you just might not know what it does. So if you don't put it in writing in a legally binding document, Florida law is going to step in and make one for you. That's through the process called probate, where they will apply Florida's what we call intestacy laws to someone who does not have a will or a trust, and they will get your things to the people that Florida law says that they should go to, which is often not who you would want them to go to. Do you need a plan? I can't answer that. I don't know your individual situation. I know yours, but not everybody else's. But if you know who you would want to get your things or who you would not want to get your things or who is appropriate to serve in certain roles and who is not, then you should probably put that in writing. And just because maybe you don't have a ton of assets, that's not a prerequisite. It's, do you know what you want? Okay, then you should have a plan.
So let's say I don't have a lot of assets. I don't consider myself wealthy, but I mean, I do okay. I've got a job and maybe I own my property or I'm making a mortgage payment, but I live in a house that I've bought, or me and my spouse live in a house that I've bought. I got some bank accounts. There's not huge amounts of money in them, but there's a little bit. If I die without a plan, is that probate going to cost a bunch of money?
More than most think, actually. And Florida, depending on the net worth of your estate when you pass, there are two different types of probate that you might qualify for. If it's less than $75,000, it's a more streamlined process called a summary administration. It is less expensive. It takes less time, but it is still expensive. So at a minimum, we tell folks to plan on at least $5,000, which for a lot of people, that's a lot of money. And not only that, it comes out of your estate, so it's less money that you're leaving to your loved ones. And if the expense of it isn't a deterrent, the time commitment will be. So you're looking at about a year from start to finish, and that is if it is very simplified. So if people come out of the woodwork, there's a conflict about who gets what, it will get even more expensive and it will take even more time.
And who wants what they do leave behind to go to, attorneys?
Correct.
And courts.
Hey, I'm not that type of attorney. So.
Exactly. But who wants that? You know, for
Right.
preparing ahead of time, it will save your estate in the future or your valuables from going to an attorney and actually going to where you want.
That's exactly right. Yes. And not to mention the headache associated with when you require probate in Florida, you must, like you just said, have an attorney, which means that attorney is going to work with the court system, which means so are you. So you're really at the mercy of the court system as to how long it takes, and that just depends county to county, during which time you do not have the ability to manage those assets at all. You can't sign for insurance, you can't refinance. Your hands are literally tied until it gets through, at which time then the court decides where they go.
And they generally start, from my experience, with a minimum $5,000 retainer. So $5,000 right up front, we've done nothing. And you're leaving your heirs the situation to come up with that $5,000 because they don't have it from the estate yet either. So what if I'm a married couple and I don't have a bunch of any other assets? Our home is our main asset. If I die, one of us, where does my home go?
In a perfect world, if the home were titled in both of your names, there would be no issue. So it would pass to the surviving spouse. Florida has spousal rights, so you can't disinherit your spouse from certain assets. Your homestead property is certainly one of those. But one of the worst cases I ever worked on when I did handle probate matters was a long-term partnership. So like 30 plus years that these folks had been together. They owned a business together. They lived in the same house together. For almost the entire duration of their relationship, they never legally married. Florida does not recognize common law.
No common law in Florida.
No common law in Florida. He tragically and unexpectedly passed away. She continued to try to run the business, but she ran into obstacle after obstacle because most of the business assets were also titled in his name personally. So she opened probate because she also didn't have her name on their home. It was his homestead property, but it wasn't hers. After almost 2 years of navigating the probate process, she basically lost most of their assets to foreclosure and repossession. And finally, from really just the graciousness of his children, they allowed her to stay in the home.
And you know that's not what he wanted.
Nope. And Florida law would not have done that for him. So that was a scenario where he really would have benefited from putting his wishes in writing.
So from my understanding in Florida, the marriage, if they would have been married, this could have been a complete different story. The marriage owns the house?
Maybe. So in Florida, if you are married, you cannot disinherit your home or your spouse from your home, meaning you couldn't give your homestead property to someone else if you passed away and you were still married. But if your spouse's name is not on title to the property, they still have to go through probate to make that happen. Florida law is going to do it for them, even if they don't have a will or a trust, but they still have to go through probate. So for married couples, that's the first thing I check when we sit down and we pull all the paperwork from the public records to see how they own things. I want both spouses' name on the title to the property.
Okay, so I've run into this situation a couple times. I got to ask you about it. So let's say you're a single woman, you own your house, and then you start dating. Had your house before you ever met this particular partner, and then you get married and they move into your house, and it is now their homestead as well, but they're not on the title. You owned it prior to marriage. Mm-hmm. Do they have any rights to your house?
Well, you're speaking my language again. So before you got married, you're going to call me or another attorney that you trust and you're going to sign a prenup. Florida gets it right because you can either actually do this before you get married or after in the form of a post-nup. The answer to your question is yes, they do have rights to your house. So if you get married and that is your homestead property, now it's their homestead property too. They have spousal rights to that property. If your spouse has waived their rights to that property, you can do it. They just have to do it in a way that they understand what they're waiving, and it has to be in a legally binding document.
So I get married. Let's say, God forbid, my husband passes, and I meet another man, I get married, and he was never on the house. But I get married, and then I decide, you know what? This ain't working. He owns my house.
There is not a hard and fast line in Florida. So there's not black and white in Florida like there is in some states. We follow what's called equitable distribution in divorce proceedings. So if there is a dissolution of marriage, they're going to look at what you brought into the marriage as well as what your spouse brought into the marriage, and they're going to get as equitable as possible in making that determination. Chances are if you owned the property before marriage and he didn't make substantial contributions to the property, you didn't refinance it together, or you didn't use it as leverage for like another property that you own jointly or something like that, then it could be considered non-marital property, but it is his homestead too. So that means you can't do anything without his consent. That's where your hands are really tied in that situation.
And that's really where I got to go. I got to go to a court. I got to go to a judge and let them decide versus, let's say we just dissolved the marriage. It wasn't going to work. But he knows his rights.
That's correct.
Yes.
Yep. Homestead property in Florida is tricky. When you use that magic word, when you get married, it changes everything. So I do always recommend my clients, especially clients later in life that have, substantial assets when they're contemplating marriage. Prenup doesn't have to be an ugly word. It just says, hey, what I'm bringing into this relationship, I do plan to take it back out.
I actually had a funny situation with this one time. I had a lady I was selling her house for, and she was previously married, and his name was on the deed. Both of their names were. Well, he had moved out. They had gotten a divorce. She then got remarried, and they were actually separated. But it was his homestead, and they were legally married. So at closing, we had to have ex-husband, who's on the deed, as well as current husband who's separated because it was his homestead and she's legally married, show up at closing. Talk about a complicated situation. I'm like, are all these men going to play nice together?
A little awkward.
Yes.
Yeah,
luckily
sure.
they did, and everything worked out. But those were some weird conversations to have. So a lot of people, I know you do trust. A lot of people talk about trust. Is a trust right for everyone?
So no, trusts are not right for everyone. And the way that we kind of complete that analysis is based on what you own and who your players are in your game. If you schedule an appointment with us right off the bat, that's what we do, is we make a list of your assets, how you own them, how they're titled, and then the people you want them to go to when you're gone. We also sort of analyze the players in the game. Are you married? Are you not? Do you have children? Are they minors? Are you working with adults only or special needs beneficiaries? Or basically just kind of determining who it is that is going to get your stuff.
Even your dog like me.
Even your dog. Even your best friends and anybody else that you might be including in the plan. We talk about it all. And then based on the answers to those questions, so what you own, what you're doing with it, and who's getting it, then we structure the best way to make it happen. Trust work really well for people that have more assets because you can get a little bit more restrictive on who gets what and how they get it. But they're not the only solution. So trust also work really well if you own property in multiple states, because many people don't understand that if you own property in, let's say, even just like Florida and Alabama, we're right here together. You wouldn't think it's so different, but it's drastically different. You're going to have probate in Florida. You will also require one in Alabama as well, unless you have a trust. So if you have a trust, then everything's properly titled in the trust. You avoid probate in both states. Then you're probably looking at more like $10,000 to $15,000 on the back end. So it can work really well. A trust is also our preferred mechanism for probate avoidance in most scenarios where you're dealing with multiple beneficiaries. So let's say you were married, you have one child, it's an adult child, and they're getting everything. There may be a way to structure your estate to avoid probate without using a trust. But if you're naming multiple people, a trust is typically the most streamlined and efficient way to make that happen.
So let's talk about that particular thing with children. I run into cases all the time where people want to put their child's name on their deed. And I deal with the back end. So we wanted to make sure our house went to our kids. And so we've put our 4 kids on the deed, had no idea we were ever going to sell. And now we're going to sell our house and move. Life situation changed, whatever, and now we want to sell our house. And so I always have to deal with the negative consequences of that, which are all your children own your house. So they have to sign for you to sell your house, as well as the title search. There could be an issue. I had a situation, we went to sell the house. The parents had no idea. They had put their kids' names on the house. All the kids obviously were willing to sign, as well as willing to sign to release the profits to go to the parents, not them, which they could have not done.
Right.
So that was good. But we had a title search issue come up because part of the title search was on the people, not just the house, and one owed back child support. And so the back child support had to come out of the parents' proceeds to be able to close. They had no idea. The parents had no idea. I know there's other options. What other options could you do instead of just putting your child's name on your property?
Yeah, thank you for asking this question because I really hate that too when that happens, but for different reasons than you. I hate seeing that, and we do get this question all the time. And just like you see it, we have people that have tried to do something really good for their children and avoid probate, but unknowingly what they've done instead is they have created the scenario where they are now responsible for their children's liabilities during life. So even if they're not trying to sell the home, which you're right, they can't do without their kids' consent.
What if they're in a car wreck?
Correct. And that holds true. So not to segue away from property, but bank accounts too. Don't put your kids' names on your bank accounts. If it is your intent that your children inherit your home by way of a deed, we actually recognize in Florida what's called an enhanced life estate deed or a ladybird deed. In certain situations, they work really well for probate avoidance. They're not perfect for everyone, but if you're naming one, maybe two beneficiaries that you trust will get along and be able to figure out what they want to do with the home, then they can work really well. And what makes an enhanced life estate deed different than a traditional life estate deed is exactly what you described. When you sign an enhanced life estate deed, you still retain all of the rights to the property. You have exclusive rights for the duration of your lifetime, during which time you can freely sell, refinance, do whatever you want to do. You do not have to ask for consent or permission. But then if you still own it, when you pass away, it's you in advance saying, here's the folks that I want it to go to. And all you have to do is record a death certificate in the public records to make that happen. You don't have to go through probate.
And those are pretty affordable to do.
Very affordable.
Can you do those?
All the time.
Yeah.
I love them for the right people. Yes.
And I love that they're so affordable to do. And I get so many people that just want to go change the deed. And I'm like, please don't, please don't. There's other ways to achieve what you want that are very, very affordable, but not tie you up in these other circumstances.
Correct.
And of course, we all want to think our kids are never going to be in a bad situation or nothing's ever going to happen to them, but you never know.
You truly don't. And it might not be anything that they do intentionally.
No.
They get in a car accident and they get sued.
Exactly.
If their name is on your property, they're coming after your stuff every single time.
So we talked a lot about trust and wills and which one is right, but we talked a lot about property. There's so much more that goes into it. What else is included when we're talking about these trusts and wills besides property?
Yeah. So we literally make an itemized list of every single thing you own. And like we touched on earlier, that includes pets, that includes personal property, family heirlooms, things that are important to us. That includes businesses that you own, businesses that you have an interest in, your liquid bank accounts, your stocks, your investment accounts, your retirement accounts, life insurance policies. Everybody's situation looks different, but in our process, it's basically you list your assets, and then every single type of asset, whether it be real property or bank accounts or life insurance policies, they all have their own sort of right way to make it into your trust. If you're working in a will setting, it's less important to capture your assets. We still want to know what you own, and we want to keep that list current so we know what we're working with, especially if the tax laws change and your net worth matters. We need to kind of keep on top of that. But in a trust setting, it's different because if your trust doesn't own it, your trust doesn't control it. So every single asset that you have needs to have a mechanism for getting into your trust, or else your trust isn't going to work. You're still going to have to go through probate. So that's why we want to stay nice and tidy and it's not in a vacuum. So we're going to do it when you first meet with us. We're going to do it every 3 years after that. And if something changes in your world where you buy a new property, you sell a property, or something changes, you're going to let us know so we can contemplate it so that we can make sure that your goals are still accomplished and everything's still nice and tidy.
What about what I want to happen when I die? Like my actual body? where I want it, where I want my body to go. You know, I've got some crazy weird beliefs of what I want to happen. But what about all of that? That's included in it.
It is included. So not only does an estate plan get your belongings to the folks you want them to go to, your assets to the folks you want them to go to, but it also communicates end of life wishes and final disposition wishes. And for some of us that have more creative requests, and I'm included in that too, it is important that you tell people because they are not going to know what you want absent a writing where you tell them. And it might change. Let's say, you plan now and you're, young and healthy, and then you live 30, 40 more years and you see how things shake out. You might change your mind. This plan is built to grow with you. And there's actually a place where you can go in and write in a separate writing if along the way you come up with other details that are important to you. But that information is kept in a document called an authorization for final disposition. So you name the people that you trust to carry it out for you. And we typically name at least 2, if not more, so that there's a hierarchy because we never know what's going to happen. But it makes sure that there's always someone available there. And then we tell them, you want to be buried, you want to be cremated, you want to be turned into a tree, like whatever it is that is important to you. There's so many things that you can do. You can say if you want to be an organ donor, and if you do want to be an organ donor, does that include research and education, or is that just, transplant list only? Do you want to donate your body to science? That's a whole other conversation, but it is so important to let them know because the burden that it alleviates from the people that are making those decisions when that time does come is indescribable. They're carrying out what you said you wanted. They're not saying, oh my gosh, I don't know what they would want and I don't want to pick the wrong thing. It's nope, this is what Jessica said she wanted. Here you go. Here's your authority to go do it.
And I saw this happen in such a real life situation to me many years ago, I guess about probably 16 years ago. 2009-ish is about when I saw this happen. And it just resonated so strongly with me. But I had a good friend pass away. And what his wife wanted and what his mother wanted were very different. Oddly enough, I've always talked about death a lot. The night before, I had literally been with this person who passed away the night before they passed away. And we did our typical conversation by the bonfire, having a beer of what we want to happen when we die. I have no idea why I've always done this, but I have.
Perfect timing.
Yeah, right? I had no idea that he was going to pass the next day. But so his beliefs were very clear to many of us and his wife. But unfortunately, his mother didn't quite agree with him. And I watched what she went through, and I watched the amount of money wasted on appeasing, because of course she wanted to appease his mom. She wanted to be nice, but she also wanted to appease his wishes. And she spent so much money making sure everyone was happy. And, I just watched her at that particular time in the funeral home, and I'm there with her, and she's picking out headstones. And I really felt like, oh my gosh, they are just taking advantage of this poor woman. She just lost her husband and they want to just, get her to buy this and this casket and that. And I understand she's grieving. And yes, she wants to send her husband off in the best way. And I'm looking at it going, if people spent my money on that, I'd be mad.
I'd be so mad.
I'd be so mad. Do not spend my money on a casket or, but she was
Same.
doing what she thought was best. But I just saw how vulnerable she was. And she didn't know exactly what to do. And I thought, wow, if we could give our loved ones these answers. And when you got crazy wishes like me, that me and my husband both want to be cremated and made into an artificial reef so our friends can fish off of us because we love to fish. When you have some crazy weird thing like that, it's great to put it in writing. And it's so that people know and they don't feel bad and feel like they got to spend all this money on a casket and a funeral. I don't want one.
Absolutely. And we just see it play out over and over again. And, in my family too. And the way that they show their love at the end of your life can look like, well, they have to have the most expensive casket.
Absolutely.
If you've already said, oh my gosh, please don't spend your money on that. That is so not important to me. And you've given them instructions on what is important to you, then it's a non-issue.
I'd rather you take that money and go on vacation
right.
and celebrate my life, having a good time and some cocktails and an island in the Exumas than to spend the money. But most people don't know that.
I think that's most of us.
Yeah, and they feel the guilt like, well, I've got to do the best for them. I've got to buy the best for them. I got to send them off in the right way.
That's right. Yep. And along those same lines, so for end of life, decision, burial, cremation, sort of final disposition instructions, that's definitely part of that. But a living will, advance directive, for medical decisions, there can be 3 parts to a document called advance directives. That's you in advance saying what you want for yourself in advance so that nobody else has to come in and say, oh my gosh, would they want to live in a vegetative state? So you were giving that example of where you saw folks spend a ton of money on a funeral because they didn't know his wishes. Well, in the early 2000s, there was a case where it was really similar. There was a young lady with a traumatic brain injury. I think she was in her early 20s. Her husband said she would not want to live in a vegetative state.
This one in Central Florida?
Terry Schiavo.
Yeah. Yes, I remember this when it made an impact on me.
It was so interesting when we saw the rise of these advance directives then, because had she had that in writing and communicated her wishes in advance, they would have saved, I want to say they spent 7 years and $11 million litigating, and it was a high-profile case. It gained a ton of notoriety, but her family, her parents, was saying she would definitely want to live like this. She's going to come back. There's going to be a miracle. Let's keep her hooked up to everything. And she was showing no brain activity. So eventually the court decided with the husband, they did pull the plug, but not after spending an astronomical amount of money to do it. And so now what we do in advance is we say, under these very specific, limited circumstances, if 2 physicians determine that there's no reasonable probability that I'm going to recover, I do not want to live in a vegetative state.
Well, and in that case, sure, they spent a lot of money in courts, but imagine the medical bills that husband was stuck with. And that's what I kept thinking about is, oh my goodness, like he's literally spending money to fight for his wife's desires. And at the same time, every single day, he's incurring debt. And then I'm sure the parents too thought they were fighting for her wishes too.
Of course.
Or they had a hard time saying no, she would want this. You know, they had their own beliefs for what they were fighting for as well. And both parties probably thought they were right.
Right. And honestly, nobody really wins in that situation either. I mean, the outcome was not great for either one of them. But yeah, I mean, if you say in advance, hey, this is what I want, whether that be medical decision-making, end-of-life decision-making, there's also, and I tend to use it more for my medical professionals, but I offer it to everyone. But if you are in that industry and you know exactly, with specificity, exactly what you want, there's a document called a 5 wishes that we can incorporate into a living will that literally goes, I mean, it's kind of overwhelming, honestly. I didn't do one because it was like too much. But you can go situation by situation and say, in this very unique circumstance, I would want this. Or in this one, if this situation was changed, I would want that. And so the more resources that we give the people that are actually going to be carrying out these decisions, the better. And that's what we try to do.
And I think it makes it easier for the spouse too, because when they're in that situation, selfishly, they want the person to survive. They want to hang on to every hope, right? But if they have it in writing from their spouse saying, no, this is not what I want, it helps them go, okay, I'm being selfish. I need to follow my spouse's wishes.
100%. Yep. And then the other part of that, just to close that conversation out, a designation of healthcare surrogate, that's the person that you trust to make decisions for you. So we do put your spouse in that primary role if you have one typically. So spouse first, and then whomever else you would serve in the event of a common accident. Those are the people that step in and make decisions for you if you're unable to make them for yourself. And we do sign a lot of those for unmarried partners because we see the situation quite frequently where maybe these folks have been together for forever, but they're not married. And then something happens and they can get shut out of the hospital room by the family if the relationship's not great between that person and the rest of the family. So to circumvent that, it's always good to have in writing a hierarchy of people that you trust to make medical decisions for you.
So let's talk about bank accounts. And I know some of bank accounts have a payable on death, some don't. What should I do with my bank accounts and fear of where my money is going to go?
Great question. The answer to that is dependent on who it is that you want to get your stuff. If you are married and if it is your intent for your spouse to inherit your liquid assets, so bank accounts, on an individual account, you would have your spouse as the primary beneficiary. That would allow everything to pass to them outside of probate if something happened to you. If instead, maybe you aren't married, or maybe it's a business account and you want it to pass to somebody that's not your spouse, whomever you want those liquid assets to pass to should be your beneficiary. And that can work really well for keeping bank accounts out of probate. What we don't want to do is name a minor as a beneficiary on a bank account. So we run into that all the time. That was actually one of the more complex probate matters I ever worked through, was an estate where not only bank accounts, but also real property had all been left to a 9-year-old. Not great. But yeah, you don't want to name a minor beneficiary on a bank account. You also don't want to name a special needs beneficiary. So that can be a minor or an adult that's receiving public assistance due to a unique need, for example, like autism. So if they are receiving public assistance and then you give them an inheritance, you're probably going to disqualify them from those benefits. So we do a little bit of special planning for folks that have a unique or special need, and they don't belong as a beneficiary on a standard bank account. But everybody else, everything else is fair game. I would have the conversation to make sure that your beneficiary designation is consistent with your dispositive terms of your plan. We want those to be the same because that can cause some confusion. Beneficiary designations on file with the bank pay out independently of whatever your will or trust says.
Absolutely. And that's one thing a lot of people don't even think to have on hand at the bank, but you need a payable on death at every bank account. And that is one simple thing everyone can do today listening to this. If you don't have a will, you don't have a trust, you can still call your bank and do a payable on death right away.
100%.
There's so many times people will call the bank and go, would I have a will? Courts, I don't care. Banks don't read wills. Courts do.
Great. I'm so happy for you.
Right.
I'll go call an attorney.
Exactly.
Yeah.
But the payable on death is going to give them access right away. And so if you do have property and you're leaving it to your children or your spouse, they need money to keep the lights on, to hire that attorney, right? That attorney's $5,000
Yep.
just for that retainer. They need money to get things going. And if you don't have that payable on death, they're not going to issue it. They're going to wait for the courts and issue it to the state. So simple tip everyone can do right now, call your bank, get a payable on death on your bank account.
Absolutely. That's a very easy way to do some quick estate planning all by itself.
So this is one that I run into all the time, and I'm going to tell you the situation and you tell me how to fix it. And it's sad how much I've run into this, but I have run into a lot of couples where one of them all of a sudden gets dementia. And I mean, it comes on rapidly, and within 30 days, they're diagnosed and they can't sign a document. Now they need to get their spouse into full-time care, and they need to sell their home to cover the cost of that full-time care. Well, because they're married, the marriage owns the house in Florida. So because of that, they both have to sign to be able to sell that house. But one of them can't sign because they are no longer competent enough to sign because they have dementia. And so we end up having to go before a judge and get approval where they appoint someone. What could we do to prevent that? And it's something I think all married couples should do, but tell us what we can do to prevent this.
I agree with you. All married couples should have a durable power of attorney. You sign it in advance. In Florida, we only recognize what's called a durable power of attorney, meaning it is good when you sign it. That's the durable language. It remains in effect through incapacity, if ever you experience that, and then it is void at your passing. So for all things financial, including real estate, liquid assets, digital assets, you name it, it's everything and the kitchen sink. Typically, when we're giving authority to your spouse, we give them broad authority, and then they don't have to petition the court. They have that already. All they have to do is show that document to the bank or to the closing company, whomever it is that they're providing that authority to in order to carry out the action that they're trying to do, and then they already have it. On the flip side of that, if, like you just explained, they don't have a power of attorney, they do have to petition the court. That process alone can take a while. And then you're running into a whole host of other issues if during the pendency of that they pass away. Mm-hmm. So it is always my recommendation. That is one of the documents that lives with all of the other ones as part of what we call a comprehensive plan. It's normally a will or a trust or maybe both, powers of attorney, medical directives, final disposition instructions, a pre-need guardian declaration. And that's the document where, in that scenario that you just described, if they did have to go to court to show the authority of who should be named to handle their affairs, if they are no longer able to do it, the court would grant the person named in that document to serve in that role.
And it's, we all think about when we die. Well, we should, and some do, not all. But there's a lot of in-between time between life and death. I could be in a car wreck tomorrow and be in a coma.
Yep.
And I want to make sure my husband has access to everything to do whatever he needs to do, whether it's sell property, get money out of a bank, close accounts, sell investments, whatever he needs to do to keep us financially afloat while he's dealing with me in a coma or whatever it is. And by having those documents, it allows him to do that. Now, I know some couples will say, well, he can go close my bank account tomorrow. Yes, he can. But aren't there a couple of parameters if you really don't trust your spouse that much? Aren't there a couple of parameters you can put in there?
We get that question more often than I would like to admit. We can limit the authority. So if you're really concerned that your spouse is going to go in and do things that you are just not okay with, we can limit the authority. We do not have to give them every bit of the power that you have.
Well, and not just your spouse, but let's say your kids.
Yeah. Whoever you've named in the document. So successor agents as well. The way I would draft it in a perfect world is I'd give your spouse every bit of the authority that you have, so they will never run into the scenario where you have a retirement account and now they cannot communicate if you're incapacitated with that management company or something like that. But the spouse gets kind of unfettered power. We're probably going to limit it for the successor agents, depending on who they are, because it's just appropriate to do it. You probably don't want them to be able to do everything that your spouse can do. But in the scenario where even the spouse gives you heartburn, we either limit their authority or we just remind them and you at the signing appointment, they owe you a fiduciary duty to act in your best interest. Every single action they take, every single thing that they do should all benefit you, and that's the goal. And if in the unlikely event that you name somebody and they don't do that, you can always sue them, and you would probably win. But we don't want that. We want to name the right people.
No, we don't want that,
no.
But yes. Well, thank you, Amanda, so much for being here. I know this is a topic most people don't want to talk about, but I think it's really important. Me and you are just morbid and like to talk about death, I guess. But it's making sure everything's done when you do pass, when you do have to deal with the inevitable. We are all going to die at some point. Let's have fun with it and make sure what we want to happen happens. I really appreciate you being here. We will include Amanda's information on the post show notes. So if you want to reach out to her and set up an appointment, obviously I trust her. She's who did our trust. And even with all of our weird needs, she took great care of us. So definitely recommend you reach out to her and get a plan and know that she's going to look at your assets and your situation and make the best plan for you.
Yep, that's absolutely right. And you were a pleasure to work with, Jessica. And thank you so much for having me. All of our clients look different. Every single estate is going to look different. It's like a puzzle. You just got to get the pieces in the right place. So they are custom tailored plans depending on what your individual needs are. We enjoy doing it. It's been lovely to be with you today. And thank you so much for having me.
So this week for our home hack, we're going to be talking about what to do with your Facebook account when you pass, right? So we're talking about the inevitable, you're going to die. Home hack is how to set up your legacy account. So you can actually go into Facebook now and go ahead and give them permission to allow someone to turn your page into a legacy account at your passing. So I've already done this. I picked mine, and we're going to help you today do that. So if you go into Facebook, I will say it's so much easier to do from a computer. I tried to do it from my iPhone, could not figure it out. So go in from a computer, go under settings, go to the privacy center, security, personal details, and then account ownership and memorials. And you can actually select the person and choose who should take over that account at the point in which you pass to turn it into a legacy page. I think that's important. You get to decide who it is. You get to decide who continues to keep your memorial page going or legacy page going. And you can also set up there, if you choose to, have that account disabled so that it's gone if you want that, if you don't want it to continue on.
So there's also one additional feature on your iPhone if you want to go in and add the emergency contacts to be consistent with whatever you have identified in your advanced directives. If something happens to you, and the newest technology that I just found out when I got a new phone, if your phone detects like a quick
crash,
stop, it will automatically alert not only like the medical professionals, so 911, but your emergency contacts that you've got listed. If you open your iPhone and you go to your medical emergency settings, you can make it consistent with the folks that would be in charge of your medical decisions. And that's just one more step to making everything work.
Look at that double home hack today. You get two things you can do with your iPhone. Make sure the right people know when you're in an accident to show up and help help decide how you are cared for, as well as make sure that legacy account or memorial account continues on social media.
That's right.
Thanks for being here.
Thank you.
Thanks for listening to the show today. We hope you enjoyed it. If you have any ideas for topics, questions, make sure you DM me and we will get them answered. And we may even mention you on the show. Make sure you click that little subscribe button so you know every Thursday when we put out a new episode. Thanks again for listening. Till next time, it's just my opinion.